Everybody on this side of the room got it though, right? All right. Teacher's pet. We good? All right. Um, Thank you for lunch, everybody. We're going to start up with public records. So we've been through sunshine. We're going to do public records. Then we'll have ethics, and that 100 grand that I just gave everybody will come into play, part of our ethics discussion. So let's start with the definition of a public record. A public record is any document, paper, letter, map, books, tapes, photographs, films, etc., regardless of the physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. That comes straight out of the Florida Constitution and Chapter 119 Florida statutes. So a public record is any material prepared in connection with official agency business intended to perpetuate, communicate, or formalize knowledge. So let's dissect that a little bit. Public record is records which relate to your district business, like we talked about earlier. Some personal notes that you keep personal, that you write notes for a meeting, you keep it on the edge of your desk, you never talk about it during the meeting, you bring it back home with you, most likely not a public record. But the minute you use it to perpetuate, communicate, or formalize knowledge, then it becomes a public record. So you write yourself some notes, we'll stick with that example. You bring it to the meeting, you read from it at the meeting. Hey, fellow board members, these are my thoughts on X, Y, and Z. That's a public record. You should either maintain it yourself or, like we talked about, give it to the team and they'll maintain it with the other public records. So public records are determined by content. The means of transmittal is immaterial. So it can be written on a piece of paper. It could be written in crayon on a napkin. If it has that content and it's used to perpetuate or formalize knowledge about your district business, it's a public record. Records sent from or received by personal devices are still a public record if the content relates to public business. That gets back to the example we said before. Don't be using your personal cell phone to text Carmela about district business, because that text could potentially be a public record, and if you do not have it, then there could potentially be a violation. We've circled back into that attorney fee issue again. Messages on social media are public record if the content relates to public business. We talked about that. Drafts and notes that are shared are a public record. So let's say that Don prepares a draft budget for the upcoming fiscal year, and he distributes it to the board. Says this is going to be discussed at the meeting on Monday, and it's got draft stamped all over it. It's a public record because it's used to perpetuate knowledge. It was sent to the fellow board members. If you prepared that same draft and you kept it on the edge of your desk at home and didn't share it with anybody yet, it's not a public record yet. Personal records that have nothing to do with public business remain personal. So what about communications with the district's attorney? Well, believe it or not, most of it is a public record. Very limited exceptions of what's not going to be a public record. So if you send me an email about litigation, again, someone trips and falls at the pool, and they're saying, hey, we want to sue you unless you give me $500. If you, Mr. or Mrs. Board Member, send me an email about that and say, what are your thoughts on this? What possible defenses, etc. That's going to be a public record. The very limited time that attorney communications are not, litigation theory, mental impressions, some very limited exemptions. In fact, you start with the premise that most everything related to district business is a public record unless there's an exemption. And there are some exemptions, and we'll get to those. They're all found in Chapter 119. So, like social security numbers in a personnel file, that's a black and white exemption. So, do not expect privilege in written communications. General rule: discussions between a public board and the attorney are subject to the Sunshine Law and must be conducted in an open public setting. Shade meeting communications are transcribed and become a public record at the conclusion of the litigation. We talked about a shade meeting. Pretty similar violations. Unknowing violation constitutes a first-degree misdemeanor. Could be a non-criminal infraction. Also, there's the civil action having to do with attorney's fees. Let me digress a little off of the PowerPoint, and then we'll jump back into it. We do have some additional information on public records here. So as we said, the definition is found in the Florida Constitution and Chapter 119. There is no unfinished business exception to the public inspection and copying requirement. We talked about that earlier with the draft minutes. If their minutes exist, they've been transcribed, they're stamped draft, someone has the opportunity, they're about district business, to review those. The records stored in your computer about district business are public records. So again, if you're utilizing your district email address and you're able to show that I always use my district email address, then the chances that someone is going to be able to ask the court to do an investigation of your own personal computer are slim to nil. But if it's shown that you're constantly using your personal email address for district business, then you're exposing yourself to a potential problem. Email messages made or received in connection with official business are public records. We talked about that. We talked about not communicating on the Facebook and sites along those lines. So let's talk about, we've got a public record. Everybody knows it's a public record. Somebody asked for a copy of it. How does that process go down? So any person is authorized to inspect and receive copies of public records. The requests do not have to be made in writing. So while it might be nice if the board, if the district had a form that they say, hey, you want to see a copy of all the minutes over the past 3 months? No problem. Fill out this form and we'll give them to you. That's great if they'll fill it out, but they don't have to. There's nothing that says that their request even has to be in writing. We just need to be able to communicate with them. So they could walk into the office and say, my name is Andy Cohen. This is my address. I want these records. Tell me when they're going to be ready. And we'll talk about what you can charge and how long it'll take and things along those lines. And as I said before, they could scribble their name and email address on a napkin, hand it to you and say, this is what I'm looking for. Give it to me. The records custodian is responsible for making the public records available for inspection and copying at any reasonable time under reasonable conditions. So that means that you don't have to provide the records at 2 a.m. and you don't have to provide them within 10 minutes if it's a voluminous request. All of the case law and attorney general opinions on this point to is this reasonableness factor. So if I've asked for this one-page document that was in the meeting agenda and it takes you 2 seconds to provide it to me, you can't say, oh, I'll give it to you, but I'll give it to you a month from now and it's going to cost you $500, something like that. But if somebody asks for something that's quite voluminous, let's say any emails from any board member related to, I'm picking on the landscaper, relating to the landscape contract over the last 6 months, well, it's going to take the office staff and team a little bit of time to put that together. So you can't say, and I want it tomorrow. Something like that might take a week to put together. And you are allowed to charge copying costs, and you are allowed to charge for the time involved for putting it together. You're allowed to charge for what the statute calls special service charges for extensive use of clerical or supervisory labor or extensive information technology. who knows what that means, okay? There's a lot of opinions, attorney general opinions in case law trying to interpret that. But it basically means that you can charge for that staff time and you can charge for costs and you can only charge a staff rate. So you can't say, yeah, it's going to take 10 hours for our clerk to put that together and it's $500 an hour. You charge for whatever that staff time is, and you can provide that at the beginning. So the requester who requested those emails, you can say, we've done a search, we have what you need, it's going to take us 10 hours at $30 an hour, that's $300, and we estimate the copying costs at another $100. Give us $400 and we'll get that information for you. And then the requester can decide to either pay that or say, forget it, or limit it. Say, all right, you know what? If it's $400, I only really need it over for the last week. How much is that going to be? Something along those lines. As we touched on before, pretty much everything is a public record unless there's an exemption. And there are exemptions. Your security video is an exemption. So this comes up a lot. If there is a problem at your front gate, say a gate runs into a vehicle or something, and you know someone is trying to get an insurance claim and they ask for your video, you do not have to provide it. It is exempt. You can if you'd like, but you do not have to provide it. You do have to provide it to law enforcement if they request it. And if the other person, just a private individual, wants it, and you do not want to provide it, they need to get a court document. Sometimes they do. Sometimes they're involved in some litigation with, getting their car repaired or whatever. You get a subpoena served on you from the court, and no problem. We provide the video. There are other exemptions you might think about. Like we said, so if someone asks for a personnel file, there's social security numbers are exempt. Personnel files in general are not, though. So the general information in there, unless there's other exemptions, like maybe a drug test is an exemption, things along those lines. There's a temporary exemption having to do with RFPs. So if you have a sealed bid process, those bids do get to stay sealed until you have opened them and had an opportunity as a board to discuss it, things along those lines. So the public records law, like Sunshine, is construed in favor of open government. So exemptions are strictly there's also other exemptions for personal information of like police officers and judges and things along those lines. One of the things that trips people up sometimes is that private vendors that are doing work for you are subject to the public records laws. So I'm picking on the landscaper again. That landscape contractor, if they have some public records of yours, they can't hide them. You can't give the stuff to that private vendor and then it's like, oh, I'm a private individual. You can't get those records. They are subject to the public records laws. And when we prepare a contract, we put a provision right in that vendor contract that says, hey, Mr. Vendor, please know that you are subject to the public records laws. You need to maintain these records that you might have of the district. If you don't want to be the public records custodian, then make sure either that the district has the records or that you provide them to the district. Let's see. Consequences, yes. Yes. It's that they are public and they become public at the time that they are dispersed to the trustees. And so you don't have to provide them to everybody in the park. But if someone comes in and says that I would like a copy of the backup for the agenda package on Monday, you would have to provide it to them. Again, if it's extensive, you could charge, things along those lines. You do, and I see your hand. But the one thing to also know is they cannot do a standing request unless you agree to it. So they can't say, every time there's a meeting, I want you to send me the package. Okay. You could say, fine, I'll do it, no problem. But they can't make you. So they would have to come in each time and do a public records request. Yes. Mm-hmm. Mm-hmm. Right. 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 But if somebody said, after it had been dispersed to the board members, had said before the meeting, I'm not going to be at the meeting, I can't watch the live stream, I still would like a copy of the packet, they're entitled to it. Again, if it's this big and it's going to be a huge copying cost and take you an hour, you can charge for it. So the penalties for violations of the public records laws, back onto the slideshow, are like the sunshine laws, criminal, non-criminal. Next slide, sunshine and public records headlines. And then the next one, as I said, you're going to see, read all those headlines. Manatee County, Northport, Manatee School Board, Sarasota City Manager. The next slide is a picture of a former Manatee County Commissioner. The next slide is a former Manatee County Commissioner. And we've got City of Bradenton Beach. Then Lorenzo versus City of Venice. Then the next slide is Citizens for Sunshine versus Susan Chapman, a city council member. So that's the big one to worry about, is the attorney's fees. I mean, that last case, Citizens for Sunshine versus Susan Chapman, the city actually won. Okay, they were sued. The judge found that after a two-day trial, the judge found that the commissioner's decision to attend a meeting with another serving commissioner did not technically violate the Sunshine Law, but that those holding public office should always endeavor to avoid even the appearance of impropriety. So they, quote, won. They spent $400,000 in attorney's fees defending the case. So that's not really a win in my book. Okay, so now I'm going to switch over to our little public records exam that you should have in front of you. It's like this, similar to the Sunshine one we had. So, number one, electronic communication between board members related to district security issues are public records and must be preserved in some format for access by inquiring parties. The answer is true. So, as we said, it's not just traditional pieces of paper, emails, tapes, like those tapes of your meetings, recordings, things along those lines. As long as they fit the rest of that definition of being district business and used to perpetuate knowledge, are a public record. Number two, a district board member is not able to attend a regular board meeting. Because Board of Trustee meetings are so awesome and exciting, and the board member does not want to miss one single moment, the member's 10-year-old granddaughter eagerly attends and takes detailed notes with a pen and paper, a relic for the grandchild, to let her grandparent know exactly what excitement he or she missed. The notes of the grandchild are public record subject to inspection. Actually true if they're given to the grandparent because they're used to perpetuate knowledge. It would be false if they kept them. But the minute that they took those notes and then handed them to the grandparent and used them to perpetuate knowledge, public record. Number three, well, tell your grandchildren. Not that you could ever get them to a meeting, probably, but that's true. Probably be on their phone. Number three, a district's manager, Carmela C., we've change the names to protect the innocent. In preparing a spending policy for review and approval by the board, produces a draft policy, clearly marked draft, circulates it to the board for review and comment. The draft is a public record, subject to inspection. We already talked about that. No unfinished business. If Carmela had kept that draft on her desk and not sent it to anybody, and would not be a public record. Mr. Henry Park is a loyal, faithful employee of the district. Mr. Park has a checkered past before finding his true calling working for the district. The district receives a public records request for his social security number and any previous drug test. The requester is entitled to review. The answer is C, the file minus the social security number and drug tests and other material which may be exempt. D is not correct, because what you are required to do is just redact the information that's exempt and produce the rest of the file. Same would be true if there was another document. Say there was a report or something that had someone's exempt information on it. You can't hold back the whole document. You would just line out the exempt information. Yes. Mm-hmm. If there's a public records exemption, and if it's something that's protected by HIPAA, then most likely there is an exemption that exists out there for it. And those exemptions would be listed in Chapter 119 Florida statute. Then you would redact that as well. If there's an exemption for it, and a lot of the things that you just rattled off, there usually are exemptions for, then yes, you would hold it back. If it's a document, like say it's a one pager, you could hold that document back. If it was 2 lines in a 6-page document, you would redact that information and produce the rest, produce the redacted document. Number 5, an unknown person going only by the initials AC sent a written public records request in crayon and written on a scrap piece of paper to the district for all district manager contracts of the past 5 years and only gives a P.O. box for sending information. The district should A, respond and tell him or her the records will be available but only between 2 and 3 a.m. Respond only after the anonymous requester identifies himself or herself. Ignore the request. That might be the popular one, but it's D, none of the above. So they don't even have to identify themselves. They could say their name is Superman, and as long as you have an email address or a way to get them the documents that they are requesting and they pay, if it's something that needs to be paid for, you have to respond. The same unknown person sends the same request to the district's landscape company, which has a standard clause in its contract with the district, inserted by the district's ever vigilant counsel, that it agrees to comply with public records laws. However, the vendor is private for profit. The corporation must still respond. We talked about this. The answer is true. They cannot hide behind the fact that they are a private vendor if they have public records of this district. Number 7, the district receives a written public records request for all amenities, facilities, maintenance records since the district was formed. The paperwork is quite voluminous. The district is ecstatic to respond and can charge for responding as follows. It's A, can charge for copies and staff time pursuant to district rules. You can charge a copying cost. You can get a deposit beforehand, like we said, and you can charge for that extensive use of time. The same requester in question 7, this time identifying himself as Super Lawyer, requests a summary of all pool maintenance firms for the district since inception. The district must respond as follows. B, produce the summary only if it exists. So you are not required to create documents. If you have a summary and it exists, you would need to produce it. But if not, you could simply respond, I don't have a summary. If they then say, well, then just give me all the records, again, you would produce them with potentially a charge. Once the district receives a public records request for non-exempt public records, it has to respond with C, a reasonable amount of time. And that's literally what the law says. So it's sort of tailored to each individual situation, as long as you're acting in good faith. 10, a district board member exchanges emails with a resident about the roadway infrastructure, and he or she uses his or her private email address rather than the district-related one. The district then receives a public records request for all emails related to roadway infrastructure. Because the district board member used his or her private email address, and because there are personal emails on his or her computer, those emails are not subject to review unless the board member gives permission. False, exactly. So if it's CDD business, it's subject to disclosure. Who cares if you have other personal items on your computer? And you have no veto power. So the board, the staff or your clerk or whomever requests that information, you can't say, no, I got other stuff on there. You don't have that veto power. A violation of the public records law is subject to the following, all of the above. We've gone over that. Number 12, I'm glad this silly test is over, but I now consider myself a public records request expert. That is true. We all know that. So that is Sunshine and public records. Now, if everybody's ready, we're going to do ethics. Okay. So, it used to be that I came and only talked to you about Sunshine and public records. About a year and a half or so ago, the legislator saw fit to make it that every special district board member had to have training in ethics, public records, and Sunshine. It had always been a requirement for certain other officers, like municipal officers and county commissioners and things along those lines. So now I come and talk to you about ethics as well. And ethics is found in Florida in Florida Statute 112.3142. That's the exact part where you're going to find the requirement that you have to have the ethics training. Florida Chapter 112 in general is where the majority of the ethics background lies. So we've got Chapter 112, we've got Article 2, Section 8 of the Florida Constitution. So just like Sunshine and public records, you've got a statutory provision as well as a constitutional provision. And then you are free to adopt additional locally adopted ethics codes and rules. I don't believe that you have, and most special districts don't. They simply rely upon what the state has enacted. So, up to the slide, Florida's ethics law. Florida's ethics code applies to all public officers, including special district board members. It's premised upon maintaining a public trust and prohibits public officials from using their office for private gain. Private gain almost always references a public official's financial interest that is directly enhanced as a result of the vote, where the gain is direct and immediate. So, I'm going to tell you, I'm glad you asked. What I will tell you is that I'll talk to you about ethics laws. We can look at statutes. We can look at the Florida Constitution. What it all really comes down to is if it doesn't feel right, it ain't right, okay? I'm telling you that. What the case law, what the Attorney General opinions look at, and what the question you just asked is they look at private financial gain. So does it inure to your own single private benefit? Now, you guys on your boards and your committees, you're all here to serve the community. And serving the communities, to some extent, serves your personal interest as well. It just does. So if you're voting on a brand new resurfacing of the swimming pool, okay, it's going to enhance the community. It's going to enhance everybody's property values, including your property value. Is that okay? It is. It really is how attenuated that is. Let's say you're going to vote on something that's going to affect everyone just on your street. and it's going to improve the streetscape. It's going to improve everybody's home on your street. Are you allowed to vote on that? Yes. Let's say, we'll make it harder. You're going to vote on something, a huge landscape improvement. It's going to be right in front of your house. The only one who will be able to see it is you. The only person whose property value is going to be enhanced, and it's going to be enhanced significantly, is you. That's probably a problem. So you would not vote on that. So what if you have an ethic question? What if you have a conflict? First thing you need to do is disclose it. So you would disclose at the public meeting. Back up. You should always be voting at a public meeting. You should never abstain unless you have a conflict. So you would announce, hey, agenda item number 3 is this awesome fountain. It's right in front of my house. I believe I have a conflict. I am going to be abstaining from voting on this issue. You also have to fill out a form. I believe it's Form 8 that your clerk's office has a copy of, and that you fill out why you didn't vote and your name and such, and it gets filed with the minutes from that meeting. And so that is the way you would take care of that. So it's a private financial interest is when you have a conflict vote. So a public office is a public trust, which means that you have to file disclosures. So you file, everybody who's on the board, on the big board, on the board of trustees, you file a Form 1. And that outlines some of your financial disclosures. It is not, I don't have to do it, so, but I'm told that it's not that complicated. It's pretty general. Municipal officers have to file something that is much more detailed. They have to reveal a lot more personal information about their financial investments and things along those lines. There was a push to have special district board members have to do that same form. It was not successful. I don't think it will ever be successful. There was a huge push back because people were quite rightfully saying, we're doing this not for the glory, not for the financial compensation. We're doing this for the benefit of the community. We shouldn't have to go through this stumbling block. So, but you do have to file your Form 1, and your Form 1 is where you're going to check that box that you've had your training. So, a public officer shall not abuse his or her public position to obtain a disproportionate benefit for themselves, relatives, or for any business he or she contracts with. So just like we said, the general rule is you can't do something that inures to your special private gain. If you unpack that a little bit, it will relate to certain members of your family, and it will relate to certain of your business interests. So, and we'll have some examples about this in the exam, but if you own, I keep picking on landscapers, but if you own a landscaping company and you are a board of trustee board member and you're going to vote on whether to hire that landscape company, you're going to have to abstain and file the appropriate forms because you have a conflict of interest. If the board is decided that they want to hire an assistant district manager because Carmela's just way overworked, and that person happens to be your son, you have a conflict of interest. So again, a lot of these things should be second nature. So ethics code reads like a book of prohibitions. Prohibits soliciting or accepting bribes, or anything of value for a vote. Prohibits soliciting and accepting gifts. You can't misuse your public position, and you cannot engage in nepotism. So again, we'll flesh this out a little bit, but let's talk about the gifts for a second. So I gave everybody 100 grand, okay? If it was truly 100 grand, you wouldn't be able to accept it. Guess what? There is a limit on gifts as public board members that you can accept. And it's usually $25 and below, you can take it and you don't even have to report it. Up to $100 you can take and you have to file some reporting requirements. I will tell you, just like I was talking before, how I like to provide advice on the conservative side. Don't accept any gifts, okay? It's just a better course of action. I have board members sometimes, it's the holidays and one of their providers wants to give everybody a $5 gift card for Starbucks, okay? It's okay, but you can never, ever take a gift, no matter how much, even if it's a penny, if it's to influence your decision. We won't even call it a bribe, but just to influence your decision. So who's to say that when you took that $5 Starbucks card, it wasn't so that your contract was up for renewal and, they want you to be in their good graces? Buy your own coffee. You don't need $5 won't get you very far at Starbucks anyway. So I just say stay away from that. Don't, it's not worth it. You cannot corruptly use your position. So again, you cannot tell, hey, vendor, give me those free Taylor Swift tickets and I'll make sure that you get the contract. Guess what? And then the nepotism. And we'll delve further into that because there are certain family members. There's a whole chart of who's acceptable and who isn't. Your sixth cousin, once removed, you don't have a problem. Your son, your wife, your husband, things along those lines, you're going to have a problem. Yes. No. It can be, it's very broadly defined. So it can include loans, it can include rewards, it can include favors, it can include future employment. Hey, you hire my landscape company and I'll make sure to give your son a job. Something along those lines, that's a gift. Doesn't necessarily have to be on I'll give you $100 bill. You are allowed to take gifts from your relatives for whatever reason. Not sure why your relatives are giving you gifts as part of your district business, but okay. If you take a gift, touched on this a little bit, there are reporting requirements. So you can never accept a gift for a quid pro quo, period. End of story. But if it's just a gift, you can accept gifts valued between $25 and $100 from a vendor or a lobbyist doing business with your agency, but you needs to be reported by the donor and by you. Gifts valued over $100 require disclosure on a quarterly gift disclosure Form 9, it's called, and there's no obligation to file that form if you're not taking any gifts. So again, you've opened yourself up to having to do all this additional paperwork. You've brought into question, why did you get that gift? We're back to talking about what we were talking about before in terms of perception and all of those bad issues. So buy your own coffee. You cannot misuse your public position. And here's another thing. You cannot improperly use information not available to the public. So let's assume that because of your board of trustee duties, you know that a piece of property is for sale in the district for whatever, $10,000 less than it normally would be on the market. You can't, because the only reason you learn that information is through your supervisory duties, you cannot then go out and buy that piece of property and resell it and make a $10,000 profit. Sort of insider trading type issue. You can't do any lobbying. I'm not sure any of you are interested in doing any lobbying. For 2 years after you leave office. You can't do business with your own agency. We touched on that a little bit. If you have your own pool maintenance company, and we'll get to this in the test because there's a little bit of an attenuation. What if you own stock in a pool company? Well, that's a little bit different than that you're the CEO and you control everything that goes on in that company. You can't do business with that company under certain levels. Nepotism. You can't appoint, employ, promote, advance, or advocate for a relative in an agency position. And the key here is exercising control. So, if you are the board and you are going to hire that same landscaping company, and it just so happens that your son works, it's a multinational company, and your son works for the division in Iowa, mowing grass at residential homes, you're probably going to be okay because you don't have any control over the hiring and firing of your son. And there's a statutory definition of relative, and it's limited to certain familial relations: father, mother, son, daughter, brother, sister, uncle, aunt, first cousin, nephew, niece, husband, wife, in-laws, steps, and halves. So that sixth cousin once removed is okay. So what if you had a conflict, you didn't announce it, vote was taken, there's a problem now? What happens? Well, it does not void the whole vote for the board, but what it does do is get you in trouble. So the conflict exposes the board member, not necessarily the whole board. And I will tell you that filing an ethics complaint is one of the easiest things to do. Maybe that's good, maybe it's bad, but it's right on the Department of Ethics website for Tallahassee. Anyone can download their form, file a complaint. Doesn't mean it has any validity to it. It will get investigated, but it's very easy to file one. That's right. We talked about that if you do have that inuring to your private gain or loss, abstain from voting, announce it, and file your form. If there's ever a question, you can always reach out to me and say, hey, we've got this agenda item. Like we said before, going to improve my whole street. Andy, can I vote on this? I'm going to tell you, I think you're okay. All public officers must fill out their Form 1 that we talked about. Requires reporting your sources and types of financial interests. Does not require monetary values. Yes, sir. No, just the big board, the ones who make the big bucks. It has to be filed annually. It used to be in the mail. They do it by computer now. And there's also a Form 1F that you file if you leave your position. So all of this is governed by the Commission on Ethics. As I mentioned before, there's a whole commission created to investigate complaints, and it's a 9-member board that serves 2-year terms. 5 are appointed by the governor, 2 are appointed by the president of the Senate, and 2 are appointed by the Speaker of the House. Those members are not permitted to hold public employment during their terms. They meet in Tallahassee. Another useful tool about the Commission on Ethics is that they will render an advisory opinion. So let's say you've got enough time. You know that landscape company is going to be before you next month's agenda. You know that your son, works for the division in Minnesota. You can write to the Commission on Ethics, describe to them the situation, and ask for an advisory opinion. Now, if they write you back and say, don't do it, and you do, you got a problem. But if they write you back and say, it sounds fine, it's not a total get out of jail free card, but it's pretty close. So you can wave that around and be like, hey, everybody, I got this opinion. I'm cool. I'm going to vote on this. So it's just like anything. You need to be careful what you ask for and be careful whether you want the answer or not. But it is a useful tool sometimes, and I have utilized those. I had a they're complicated, but I had a district where one of the board members owned a software company, and he owned it. He was the CEO, and it was he wanted to offer the services to the district for their gates. I think it would have been much more efficient, and it would have saved them a lot of money. And we asked the ethics commission whether that could be done, and he was offering it for free, by the way. He wasn't going to receive any remuneration. And I had my concerns, but we asked the ethics commission, and they said, and they hinged their opinion on the fact that he was not inuring any special private gain because he was not charging anything for it. They allowed it. So that was, I was actually a little surprised, but they said that it was fine. We had the opinion in hand, and the district was able to avail itself of those services. They're still using it. He's not making anything off of it, but the residents are benefiting from it. They cannot conduct an investigation, though, until a complaint is filed. So you don't have to worry that the ethics commission is out there sitting in the corner lurking and they're going to come after you on their own volition. It is complaint driven. Let's see. So, as we said, the complaint is available on the website. It will be investigated by an investigator. If probable cause exists, a hearing will be scheduled. And then after the hearing, they will decide whether a law has been violated and recommend a penalty. There's a 5-year statute of limitations on ethics complaints. And I will say that most complaints are typically dismissed. They're either a minor violation for which the commission might not find anything for, or it's usually just a disgruntled resident or something like that, and it never goes anywhere. The information stays confidential until the decision has been rendered. What are the potential penalties here? Well, you could be, again, it's against the individual member here. So you could be removed from office, you could be impeached, you could be reprimanded, you could have a salary reduction, so whatever's less than 0, you would get. You might have to pay restitution. Let's say you did benefit with those Taylor Swift tickets and they're worth $1,000. You might have to pay for those. There are civil penalties up to $10,000, and there are fines. By the way, there's also fines if you do not submit your Form 1 on time. So keep an eye on that. It's $25 a day and up to $1,500. Every year, you have to submit your Form 1 while you're serving. And then when you leave, you submit what's called the Form 1F. So what if an ethics complaint is filed against you? What do you do? Well, don't panic. As I said, they're confidential, at least at the beginning. Call me or legal counsel you're comfortable talking to. Find out whether your district will provide a defense. I'll talk about that in a second. Report it to insurance, see if there's any coverage, and you might be forced to obtain independent legal counsel. So we have, for the district board members, errors and omissions. And I talked about this a little bit when we were talking about Sunshine. You have an errors and omissions policy. As long as you're acting within your fiduciary duty, you are going to probably be defended by the insurance company. And if not by the insurance company, your district board is probably going to indemnify you because they're going to say, hey, you were doing your job. We're so sorry this happened. We don't know why insurance isn't providing, but most likely you're going to take up the defense. But if you were doing something outside your fiduciary duty, you punch somebody at a meeting, you're not going to have insurance coverage, you're going to get in trouble, and it's probably going to come out of your pocket. So you need to keep those things in mind. Public officers are servants and agents of the people to execute the laws which the people have made. So everybody takes an oath upon becoming a public official. That is, there's a slide here for it, but it comes straight out of the Florida Constitution. Next slide is indemnification and public service, which we already talked about, that there are certain statutory restrictions. You might have your own local, when I say local, I mean district-wide policies that will provide indemnification, and there's insurance. So unless there's any questions, I'm going to go to our ethics law exam. Which looks like this. So, well, before I get to that, I will say, now that we've talked a little bit about ethics, I think you'll know that if I truly gave you 100 grand, it's above. First of all, if it was to influence your vote, it's out, period. Second of all, it's above anything that you'd be able to disclose and still be okay with. That candy bar, that's going to be okay unless I gave it to you to influence your vote. If you're just hungry and you want to eat it, go for it. All right, number 1. The Flatland Park and Recreation District is governed by a 5-member board of trustees, and Peter Parker is the chairman of the board. The district owns various community infrastructure, including the clubhouse and pool. The district employs a park manager. The manager is a salaried employee. These are long. Who is responsible for handling certain administrative duties relative to the operation of the community. Recently, the person previously employed as the park manager abruptly quit. The district board is desperately looking to hire someone to fill this position. Park manager is hired by the board of trustees, but traditionally has reported primarily to the chairman, who is known as the liaison. Chairman Parker's wife, put a lot in this one, recently retired, and she is interested in the park manager position. It would be so convenient for her to fill the position, since she would literally be working right down the block from her home. Which of the following is the most accurate statement relating to the ethics law? And the answer is C. The district cannot hire Chairman Parker's wife unless Chairman Parker resigns from office. Because 112-3135 prohibits a public official from appointing, employing, promoting, or advancing a relative in a position and agency in which the official exercises jurisdiction or control. Number 2. Joni Jones is an elected supervisor on the ABC Community Development District. Joni was elected to the district's board 3 years ago. The law firm of Dewey, Cheatham, and Howe was competitively selected to be the district's legal counsel. The district's board and manager have all been happy with the legal services they receive from the law firm, and they are not looking to switch counsel. Joni's boyfriend, Sylvester Slickster, is a probate lawyer and a partner with the DCH firm. Sylvester only handles wills, trusts, and other estate matters. He does not practice in special district law. Sylvester's law firm is having a 4-day firm retreat at an all-exclusive resort in the Bahamas, and Sylvester invites Joni to accompany him. Sylvester told Joni his firm would pay for her travel, meals, lodging, and entertainment, as each member of the firm is allowed to bring a spouse. Joni really wants to accompany Sylvester. She's never been to the Bahamas, and it sounds like such a fun vacation. Which is the most accurate? The answer is C. If Joni pays her own way for the cost of travel, meals, lodging, and her entertainment, Joni will not have received a prohibited gift from her boyfriend or the law firm. Now, if Joni had accepted it, she will have received a prohibited gift if the expenses are valued at more than 100, as this most likely would be. As a provider of services to the district, Sylvester and his law firm are vendors doing business with the district. And even though he doesn't exactly do their work, his firm does. And he is one of the partners. So that's why C is the most accurate answer here. If Joni wants to attend the weekend getaway, she must pay her own way. And if she pays her own way, she's provided adequate consideration and has not received a gift. Bless you. Number 3. Paulina Principal is an employee of the Padre Municipal Improvement District. Paulina rents an apartment and is a registered voter with the PMID. Paulina is displeased with the recent policy decisions of the commission relating to infrastructure. Paulina and her neighbors are concerned about safety and want more sidewalks and street lights installed by the PMID. Rather than listening to Paulina and her neighborhood group, the commission has decided it's best in the interests of PMID residents to fund a large-scale road maintenance project. Paulina is outraged by this decision. The chairman of the commission is up for re-election. Paulina believes it is her duty to run against him and unseat him to effectuate the much-needed change on the commission. Which is the most accurate here? The answer is B. She can serve as an employee of the district and as an elected official, but only if she is serving as an elected official at a special district other than the PMID. So a public employee is prohibited from being a member of the governing body the governing body which serves as his or her employer. So, sorry, Carmela can't join your board. Number 4, Andy Activist is currently an employee of the South County Fire District. Andy resides and is a registered voter in the North County Fire District. Andy runs for and wins a seat on the North County Fire District Fire Commission. He's sworn into office. At his first meeting, Andy hears the fire chief announce that the district will be hiring 3 firefighters and an administrative assistant. All of these positions and salaries were budgeted for last year before Andy was on the commission. After the commission meeting, Andy calls his buddies at the SCFD to tell them about the firefighter position openings. Everyone knows that the NCFD pays firefighters the highest salary. Andy also calls his sister, who was recently fired, to tell her about the administrative assistant position that is available. Which is the most accurate? The answer is D. So, as long as Andy does not attempt to influence the fire chief's hiring decision and persuade the fire chief to hire his buddies and sister, there's no violation of the anti-nepotism prohibition in the ethics law. Number 5, Bill has been a licensed realtor in Florida for 15 years. He was recently appointed to the Channelside Drainage District. Bill accepts the appointment to the board and immediately meets with the district manager, who tells Bill about the district's difficulty over the past few years finding the right size property at a reasonable cost. Bill asks the district manager how much the district is willing to spend on the property, and the district manager replies, "We have budgeted $1 million. But if we had to, we could dip into reserve funds and spend an additional $125." After talking to the manager, Bill contacts one of his former clients who owns the perfect site for the retention needs, and Bill asks him if the property is for sale. The former client asks Bill how much is being offered. Bill does not reveal that the district is a potential bidder. He does, however, tell his former client that the potential purchaser can spend up to $1,125,000. D is the answer. Bill has potentially violated the ethics laws and misused his position by using confidential information, that extra $125,000, to benefit his former client. Number 6, Luke Skywalker is a licensed realtor who owns Skywalker Real Estate Group. Luke was recently elected to the Stormtrooper Improvement District. After winning his seat, Luke meets with the district's director, who shares with Luke the struggles the district has had locating a property large enough to store the district's fleet of trucks, tractors, and mowers. After the meeting with the director, Luke recalls that a long time ago, in a galaxy far, far away, he sold a large piece of unimproved property on Galaxy Road to Han Solomon. Luke approaches Han and inquires whether that large piece of property is for sale. Han tells Luke that, quote, "everything is for sale." Luke recalls a wise advisor counseling him on Florida's ethics laws immediately after he was elected, and he knows he cannot ethically handle the transaction. Excuse me. So Luke asks one of the associate real estate agents at his real estate firm to take over the negotiations. Luke stays out of all involvement in the negotiations. The real estate associate fills out the standard forms, includes a purchase price, $500,000. Because that is what Zillow lists as the fair market value. Luke's associate keeps the commission, 3% from seller, 3% from buyer, since he handled the transaction for both parties. The entire district board considers the real estate contract prepared by the agent at Luke's firm and votes to approve it unanimously. The answer is E. So both C and D. Luke violated the ethics law because he's the owner of the firm, is prohibited from doing business with the district, even though he never touched it, even though that associate did all the work. He has that close affiliation, and he's the owner, and most likely going to have some financials, remuneration flow his way. And Luke violated the ethics laws by participating in the vote on the real estate transaction. Number 7, Daniel Storm was recently elected to the Board of Supervisors for the Green Acres CDD. CDD has gone out to bid for a new landscaping contractor. At the publicly noticed meeting, the manager distributes to the board all of the bid submittals received from landscaping vendors, instructs the board to review the submittals so they can select the vendor at the next meeting. The lowest bid among the vendors was from a landscaping business named Lush Landscapes. After the meeting, Daniel happens to see the owner of Lush at the grocery store. Daniel knows that Lush employs between 75 and 100 teenagers each summer to assist them with lawn care. Daniel's son is in high school and needs a part-time job during the summer months while school is out. Daniel immediately approaches the owner of Lush and asks him whether he will hire Daniel's son for the summer. The owner says he would be happy to employ Daniel's son if Daniel can make sure that the landscaping bid is awarded to Lush. So the answer on this is E. The owner of none of the above. The owner of Lush has clearly tried to bribe Daniel. Criminal charges should be filed against him by the state attorney. No, he's not the one who's in trouble. Daniel may vote on the landscaping award because any special benefit Daniel's son may receive from the part-time job is remote at best. That's not correct. If Daniel discloses his son's anticipated employment, votes on it, and files a memorandum, he's fully complied. No, he can't vote. And then D, Daniel may vote to award the lawn care bid regardless of the exchange that occurred. That's not right either, so it's E. Okay, we're getting there. Number 8. Ernie is an engineer and partner with Ringling Engineering, the largest engineering firm in the state. Ernie is considering slowing down his practice, but he doesn't want to fully retire. Ernie and his firm are independent contractors that serve as engineers for the Crystal Clear Water District. Ernie was the primary author of the district's water control plan. Everyone acknowledges that Ernie is the most knowledgeable person. Recently, one of the district's board members died. Ernie submitted his name for appointment to fill the vacant seat and was appointed unanimously. Ernie will be able to serve in the board position for the next 2 years before having to run for re-election. The answer is C. Ernie can accept the appointment here and continue to serve until he is reelected because there's sort of a grandfathering that took place. That all took place before he joined the board. And basically what I said, there's a limited exception to the prohibition on doing business with one's own agencies that permits individuals with an existing contract to continue. 9. After a day-long administrative hearing before the Florida Ethics Commission in Tallahassee, the commission found that the director of the Palms Water Control District committed several violations. Which of the following penalties is he subject to? And the answer is A. So reassignment, that can't be done. Civil penalty, not for the ethics violation, or not for $100,000 anyways. And 1 year in jail, the answer is A. 10. Many residents with the active community development district have been outspoken at the last meetings about the need for the board to provide additional rec facilities within the community. After hours of public comment on the subject, the board is convinced that 6 pickleball courts will fulfill the community's needs. The board has directed their engineer to conduct a feasibility analysis relating to land acquisition and construction costs so the board can develop a budget for the construction of the 6 courts. Lenny, landowner, owns an acre of vacant property near the clubhouse. The chair of the CDD calls Lenny and asks him whether he would sell the property to the CDD, what his asking price would be. Based upon the facts presented, which of the following is the most accurate statement relating to the ethics code? The answer is C. There's nothing in this scenario that violates the ethics code. So, not everything's an ethical violation. Not even the things I put on my exam. Last one, number 11. Assume all the same facts as in 10 above, except also assume that Lenny is a member of the board, that his 1 acre parcel is the only unimproved real property within the district of a sufficient size to meet the needs for the construction of the courts. Based upon the facts presented, which of the following is the most accurate statement? Answer is D. Lenny may be able to sell the property to the district if the property is the only source available. The sale price is based on appraisal. There's full disclosure of his interests, and Lenny obtains an opinion that the sale is not a violation of the ethics code. Whew. That's all we got. I'm glad to answer questions, though. If there are any. Tired everybody out? All right. Well, thank you very much. I appreciate it. Thank you for lunch. And I'll see everybody soon. Oh, there's one thing you wanted me to bring up, Sean. I just wanted to make sure I had a thought that since we put this whole program together this morning, that we would potentially share it with your sister districts, with Holiday Park and your Holiday Park, with Tripar and Trailer Estates. And I just wanted to make sure everybody was okay with that. So the ladies over here have created a tape of this so that anybody who wasn't able to attend can review it. And I wanted to know if it would be okay if we also shared it with the Trailer Estates and Tripar people. So I just wanted to make sure nobody had any objection. Okay, thank you. Yes. Well, good. Thank you. I appreciate that. Mm-hmm. Absolutely. All right. Well, have a good day, everybody.